Please be seated. We'll hear argument in case number 240516, Valk versus Copper Creek Distributors.
May it please the court, Mr. Sherry will present argument for the petitioner. Petitioner is reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. The spoliation of evidence has, in this court's words, a devastating effect on the administration of justice and the fairness of trial court proceedings. It is for that reason that trial court judges have broad discretion to fashion appropriate remedies for evidentiary spoliation, including, at the less severe end, a spoliation instruction.
Are you suggesting that if the trial judge determines that there was spoliation, and that's a matter of law, that there are different levels in terms of, for example, if you have a situation where the jury is instructed, well, this particular piece of evidence was in fact blank, destroyed, whatever, and therefore that can be, you presume that evidence would go against the spoliating party. What are you suggesting would be a lesser thing to do there in that situation?
Your Honor, I think if the question is, are there degrees of severe spoliation instructions among the imaginable spoliation instructions, the answer is yes.
And what would be a lesser one there? I think that there was something about a motion to compel, but I don't see what a motion to compel would do after a finding's already been made that spoliation has occurred.
Yes, I'm not sure what Your Honor is referring to by reference to a motion to compel. I think the kind of spoliation instruction that was given by the trial court in this case is at the less severe end of both the full spectrum of sanctions that can be imposed for spoliation, which do in proper cases include true death penalty sanctions, right, striking pleadings, entering default judgment. But even in the universe of imaginable spoliation instructions, this was one of the less severe that could have been given in two respects. One, it was specific to one of the three defendants who went to trial. It was specific to CCDI, the corporate defendant, that's Copper Creek Distributors, Inc. I'll call it CCDI. And two, it was a may rather than a must spoliation instruction. The pattern jury charge and some of this court's cases have considered spoliation instructions that instruct a jury that it must presume that missing or spoliated evidence would have been unfavorable to the spoliating party. This instruction only said that they may presume it. It left the question to the jury. It's also, Your Honor, I know there have been references in some of the court's decisions to spoliation instructions that are tantamount to death penalty sanctions and which may require the enhanced procedural protections that Sire and Transwestern and some of those cases talk about. The spoliation instruction given in this case is in no sense tantamount to a death penalty instruction because it in no sense prevented the defendants at trial from putting on a fulsome case of their own. There was no evidence they weren't allowed to admit, and in fact, they admitted their own evidence related to the spoliation issue in order to, as they put it in their briefing, take the sting out of the instruction.
So on that admission of evidence, ordinarily when there are discovery disputes, that stuff doesn't come in front of the jury. But when there's spoliation, often a trial judge will say, you can cross-examine about the fact that there weren't time records kept in connection with these services, so it's difficult to quantify the amount of theft. Or the QuickBooks have missing entries. You can also point that out to the jury, and you can argue that documents that should be there, looking at the full list of exhibits, are missing. Why isn't that a sufficient remedy, short of the trial court getting involved with particular aspects of the evidence?
Well, two issues, Justice Bland. One related to the practical reality in a case like this, and then one related to the case law. It's not sufficient in a case like this because the actual evidence, the QuickBook records, the emails, which we know from the little bit of evidence we were able to develop, contain important and relevant evidence both to the issues of labor theft and damage, was just missing.
Right, and can't the jury infer from that, not from an instruction, but from that there was theft, and that the theft, the amount of theft can be determined by what records you do have, because those records that are missing would have looked similar.
Well, Your Honor, that's of course what the spoliation instruction does. It
Right,
tells the jury
but
that
this
they
is the
may
argument
make.
about the disputed evidence between both sides, and you had said the other side also admitted some evidence to try, rather than the trial court getting involved with the weight of the evidence.
This gets to the case law issue that I mentioned, Your Honor. The case law of Brookshire Brothers and subsequent cases really treat, first of all, they hold that whether or not spoliation occurred and whether spoliation instruction is appropriate is something to be determined by the judge outside the presence of the jury.
Yes.
And they actually strongly discourage discussing spoliation-related evidence in the presence of the jury unless it's somehow related to merits issues.
Right.
So I think under the case law as it currently stands, I don't know how any trial court judge would conclude that allowing a full airing of the spoliation
Not of the
dispute-
spoliation, but of the holes in the evidence. So this happens all the time. There's a missing document, maybe without a spoliation veneer to it. And trial judge is faced with trying to decide, should the lack of that document, not the discovery dispute itself or spoliation hearings, but just the missing document, can you cross-examine about that? Can you argue about it in closing argument? And often the answer to that is yes, because, you know, it's a document that ordinarily would be kept in the regular course of business and it's not there.
Well,
Why isn't that the remedy for missing time records and not accurately keeping QuickBooks and the things that are alleged to have been done in this case?
Well, unless the jury is instructed that it may consider the missing evidence to be unfavorable to the party that had an obligation to preserve it and did not, I don't know how the jury would know to draw that inference. But secondly,
Well, you would
Your Honor,
argue that, and I presume that you did argue that in connection with closing argument and in addition to relying on the judge's instruction.
well, the second part of what I was going to say, Your Honor, is unless the counsel and the parties were allowed to get into not just that it's gone and what it might have shown, but why it's gone, why it wasn't preserved, or why it was destroyed, which is exactly the kind of discussion this court has discouraged in its prior opinions, I don't know how the jury would be able to draw the necessary inference either. You're either going to have to instruct the jury that the missing evidence should or may be presumed harmful to the party that didn't preserve it, or allow the parties to argue that kind of thing directly.
But if you allow the parties to argue that kind of thing, aren't you asking the jury to include in their damages award a penalty for not the actual damages in the case, but for what happened in connection with production?
Well,
And isn't that supposed to be handled through sanctions or some other mechanism?
like the spoliation instruction, yes, the spoliation instruction that the trial court decides is warranted based on the evidence presented to it. On the issue of the spoliation-related evidence that was actually admitted at this trial, there are 2 points that I think are important about why that happened and how it happened. First, it happened without any objection by the defendants or their counsel at all. Now, did they preserve an objection to the instruction? Absolutely. Did they preserve an objection to the distinct issue and what they've alleged and what the Court of Appeals considered a distinct error of discussing spoliation-related evidence in the presence of the jury? No. It was never objected to. They elicited a lot of the same related evidence themselves. They have argued in their briefing on appeal and here that they did so in order to take the taint out of the spoliation instruction. That's one point.
So I understand your point on that it's a different argument to say there was an evidentiary error or an argument error that should result in a new trial versus there was a spoliation instruction that was given that's a jury charge error that should result in a new trial. I understand those are different. But because we have the argument in front of us that the instruction was error, are you saying that that's somehow waived by the failure to object to the evidence?
No, Your Honor.
Okay.
They have preserved their objection to the
Okay.
spoliation instruction.
So let's talk about that.
Absolutely. So the Court of Appeals erred in reversing the trial court judgment in this case for 3 reasons. First, it failed to conduct an entire record analysis of harm. This court, as recently as the decision in Horton, where it provided a gloss on the importance of entire record harm analysis in the context of a Castile charge error, has emphasized over and over again that a harmless error review must include review of the entire record. It is not enough for the court to note that certain kinds of instructions have a tendency to be prejudicial, and it is not enough to intone that a case was closely contested. The court actually has to look at the record, meaning the evidence in favor of the jury's verdict and the evidence of prejudice to the losing party. That did not happen here. The Court of Appeals harm analysis as to the spoliation instruction is entirely lopsided. There is no discussion of the strength of the plaintiff's case on both labor theft and damages against the defendant. And the plaintiff's case at trial was strong. The fact that CCDI's principals, two of its principals, Donald Triplett and defendant Daryl Briggs, the fact that they were coordinating, colluding, whatever word you like, with one another to divert labor from the plaintiff's job sites was barely contested at all. Mr. Triplett admitted that he sent people off the sites. Mr. Briggs admitted that he himself was off of the plaintiff's job sites on CCDI jobs 20 to 30% of the time. The only argument that the respondents make on appeal in response to the strength of that evidence is that, oh, that wasn't evidence that they were CCDI job sites. That was just evidence that they were Triplett job sites. But I would submit, Your Honors, that that would be equivalent to me saying that Mr. Sheeks and I are not here today on behalf of the McCatherine Law Firm, of which we are both partners, and whose name appears on top of all of the invoices that we sent to our client in this case. And even though we both have McCatherine.com email addresses, because all of that evidence was present at this trial with respect to Mr. Triplett, Mr. Briggs, Mr. Escoffi, and CCDI. They were invoicing our own client under the name.
So the evidence of liability in this case is very strong, and I take your argument about harm. So how, if you could just address how the instruction itself, how are we to know that the jury didn't take from that instruction that they could penalize the defendant in the form of damages for the failure to produce evidence?
Your Honor, it's usual harmful error analysis, meaning has the appealing party, the respondents in this case, carried their burden of showing that the result probably would have been different under 44.1 and 66.1.
And your point is the amount of damages would be roughly the same whether the instruction had been given or not given.
Exactly. The damage evidence which came in and the evidence of liability of labor theft was all very strong. I submit that on whole record review, looking at the strength of the plaintiff's case and not merely the potential prejudice caused by a spoliation instruction, it is impossible to conclude that the jury probably would have resolved this case differently without the instruction. It can only be concluded that way when the entire strength of the plaintiff's case is ignored or glossed over, and that's what happened in the Court of Appeals opinion. The section on harm analysis, there is a section with the heading harmful error, completely ignores the plaintiff's evidence. There is no discussion of it whatsoever.
And I guess your other point is that some of that the jury could also have relied on the evidence and argument about spoliation because it came in without objection, and that any additional weight that there's nothing to indicate that the jury gave so much additional weight to the instruction on top of the evidence about spoliation and the argument about spoliation and the strength of your case on liability and damages to say that the instruction probably caused an improper judgment?
Absolutely, Justice Busby. I think as we've put it in our briefing, one of the things that the court can make clear in its decision in this case, which it hasn't had occasion to talk about before, is that when discussion of spoliation-related evidence in front of the jury occurs without objection, the normal rules of error preservation and waiver apply in a case like this, and that discussion cannot count toward the harm that the Court of Appeals is assessing when it evaluates whether there was any harm caused by the instruction itself.
So you didn't get to complete your list of ways that the Court of Appeals erred. I want to ask you, just in the minute you've got left, was it error for the Court of Appeals to award a new trial, to grant a new trial without considering the rendition points, the no evidence points that were raised that would have afforded the other side
I don't think it was
a
error,
different
Justice.
judgment?
I don't think it was.
So you think the Court of Appeals was right to rely on the field turf case to just hand out a new trial here without considering the no evidence points?
I don't think it was error for the Court of Appeals to decide this case based solely on the spoliation instruction. I do think that the remedy at this stage, because the Court of Appeals did not consider the no evidence points or the other 10 issues that were raised by the defendants, by the respondents in their appeal, is a remand to the Court of Appeals for consideration of those issues. I don't think this court can reverse and render. I think it could, but given the fact that those 11 issues were not considered by the Court of Appeals, I think remand is the only thing that
Nor are
would be
they briefed here.
appropriate.
Understood. I just wanted to see whether you thought it was the correct outcome to rely on the turf case.
For not rendering,
Correct.
yes, Your Honor, I do.
Well, the reason, maybe I misunderstood this, but the Court of Appeals didn't reach those rendition points on the theory that maybe you would have put on a different case but for the spoliation
That's correct.
instruction. Is that not in some tension with your idea that, oh, come on, it just didn't matter, this is just slam dunk? I'm finding there to be, both of those things can't really be true. Like, it would have been a completely different case if you had not had the spoliation instruction, but, whatever, it's all no big deal, no harm.
Well, Your Honor, I'm certainly arguing harmless error, and that certainly entails that I think we would have won, even without a spoliation instruction. The Court of Appeals, I'm sure it is true that the absence of a spoliation instruction, if that is what this court rules and sends it back that way, will affect how plaintiffs put on their case. There are, as I say, 10 other issues, including issues related to our damage model, that will have to be resolved by the Court of Appeals. However, this court decides the spoliation issue. And so, it's hard to imagine, but there's an entire world of possibility about how this case
Just
might be
one more
presented
thing
differently.
from me, and that is, I take it you're not arguing that there's anything that shows the district court gave any explanation about why a lesser sanction would not have worked. You're arguing that because of the harmless error review, we should not hold it to that obligation. Is that correct?
On that particular point, Your Honor, it is absolutely the case that the district court did not provide a record explanation or written findings about it. But the point we are making there is that that's a procedural requirement from Sire and the cases related to Sire, Transwestern, GTE, Chrysler, Newkirk decided this year that this court has only ever applied to death penalty sanctions, number one. And number two, that normal standards of review in a case where findings of fact and conclusions of law are not requested, but a reporter's record is prepared, is sufficient for the Court of Appeals to decide for itself whether the instruction was warranted on the record. And that's really our second point of error on appeal. I see that I'm out of time, Your Honor.
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Harrod will present argument for the respondent.
Thank you, Mr. Chief Justice, and may it please the court. Now, there's a lot left out on that argument as far as the timeline is incredibly important. This case was on file for almost 5 years before it actually reached trial. The original defendant was not Copper Creek Distributors Incorporated or Mr. Escoffi, the respondents in this case. It was Donald Triplett. That was the original defendant, and that was the main defendant for 2 years until he went into bankruptcy, at which point they had added Copper Creek Distributors, and they had also filed suit against his husband, Donaseth Escoffi. They had not served Mr. Escoffi before that bankruptcy filing. They only effected service in 2020, 2 years after the lawsuit had even been on file. And then even a year later, they said, oh wait, after summary judgment had already been granted as to limitations as to Mr. Escoffi, he's actually the alter ego of Copper Creek Distributors. So if we rewind to the original lawsuit, they said, Donald Triplett, you were diverting labor for your benefit or for your company's benefits. Mr. Triplett, in interrogatory answers, didn't deny that he was diverting labor. He said that was our agreement. Attached to their spoliation motion is his interrogatory answers where he says, I sent workers based on our agreement for Preferred Platinum and DFW Design and Remodeling. That was never, we never said we didn't divert labor or shared labor. It was that it was for these other entities. It's this case is about mistaken identity and them trying to pin activities related to Donald Triplett onto a wholly different company and saying, because you are an owner, it must have been that company. The timeline is important because throughout the course of this case, 5 years, there's 11 depositions that are taken. Several of the homeowners from where these projects took place. Not a single homeowner was called to trial to testify, my GC was not Donald Triplett, it was Copper Creek Distributors. Why weren't those homeowners called? They were known. They also
Is
had
this about some of the issues that the Court of Appeals didn't reach?
the sufficiency evidence issues they did not reach. And I think it's because they took a very practiced and restrained measure that said, you know what, on balance, spoliation permeated this entire case that it was so sufficient, in fact, probably every single one of the issues, almost every single one of the issues I raised, that it needed to go back for a trial. In the interest of justice, it remanded. We did not challenge that decision because we thought, on balance, it was fair. The spoliation issue, it affected the timely disclosure of damages issue. Because at trial, when that we objected to their introduction of damages because they weren't timely disclosed, despite being on file for almost 5 years, they said, well, it's the spoliation issue. We couldn't disclose damages until spoliation was determined. Therefore, that was our good cause, no surprise. And the court accepted that. So that spoliation issue likely affected that decision and whether it moved forward. Spoliation also probably affected them getting to designate and call our corporate rep. They knew who our corporate rep was going to be. We had a spoliation hearing where it was identified that Donald Triplett, not Mr. Scoffey, who's the alter ego of Copper Creek, he is the person that knows the most about these emails of some subject and QuickBook records because he's the one that set them up. He's the one that was running he was the one that started Copper Creek Distributors. So he's the one that would have the most information. They did not put Mr. Triplett as a witness on their witness list. They did not subpoena Mr. Triplett, but they wanted him for spoliation.
Did you call Mr. Triplett?
No, we were told by the trial court that we better have him here the next day, otherwise there'd be a price to pay. So we made him available.
Well, he did testify.
He did testify, yes.
Okay, so I think their argument is that this error was harmless because if there are gaps in records and failure to keep timesheets, a jury will hear about that. And when the jury hears about that, they can think, oh, okay, so this worker that works Monday through Friday, 8 to 5 on this job, is away for 2 days and there's no timesheets about that. Well, that's an 8 to 5, borrowing of that worker for another job. And they can do the calculation to calculate the damages. So I think the argument is that the instruction really didn't matter because there was evidence of damages that supports the verdict, that the verdict is not so outsized that it reveals that there was a penalty that the jury imposed or a sanction that the jury imposed rather than just a simple calculation of damages.
The harmless error analysis, I think the Court of Appeals gave it a little bit short shrift in the actual analysis is because they couldn't identify what probative evidence they elicited that this was Copper Creek as opposed to the 16 other entities that Donald Triplett controlled. Mr. Valk, the petitioner's son, Sean Valk, testified that he hadn't seen a single contract, he hadn't seen a single invoice to these projects, but he knew it was Copper Creek and not one of the other entities that Donald Triplett controlled. This notion that time records would have been part of QuickBooks goes against their whole entire theory of the case. Their theory is that you kept them clocked in at our work site and then sent them to these other work sites that we didn't agree to. You didn't have authority. Mr. Sean Valk also testified at trial that the QR codes to clock...
Why is the QuickBooks irrelevant, though? If there is never an entry for the cost of your labor in your QuickBooks, that's relevant.
Going back to even whether or not spoliation should have even been instructed, whether the duty to preserve, I think it tied into any decision or discussion about spoliation is what has been requested and what are you entitled to. At the spoliation hearing, they attached discovery requests to Mr. Scoffey, not to Copper Creek. They never made any showing as to what they requested of Copper Creek and what Copper Creek gave them. The record is entirely devoid as to whether they are entitled to QuickBook records at all. In their discovery requests, they don't ask for QuickBook records. They ask for financial statements and financial documents, which they got profit and loss statements, they got invoices, they got Copper Creek's entire bank statements. So if there's income coming in from homeowners, they had all of the bank statements. That was part of their exhibits, was the entire bank statements for Copper Creek. They chased Mr. Triplett into bankruptcy and could look at his entire affairs to know what financial ties to Copper Creek for this alleged diversion of labor. They didn't show what the responses were. The court in that spoliations hearing, I objected saying, I'm a little flat-footed because I don't know what discovery requests they were entitled to that would get them to emails. Emails about what? Copper Creek's entire domain that you knew lapsed because someone aligned with you bought the domain, which is a very interesting fact that they bought the domain and said, produce stuff that we know you don't have because it lapsed.
Am I looking at the wrong thing here? My notes show that Clerk's Record 977 says that Valk in one of the RFPs requested, quote, all balance statements, profit and loss statements, QuickBook reports, operating statements, and any other documents. So did they, was that not a live RFP?
There was not a live RFP. They didn't attach the RFP to Copper Creek from the spoliation motion. They did not identify QuickBooks by name. They never called me up and said, hey, we need QuickBooks. During the spoliation hearing, there was no testimony elicited at all as to what happened to QuickBooks. There was attached to that Mr. Escoffi's deposition, his personal deposition, because they never deposed the corporate rep for Copper Creek. Despite not being able to get any of this evidence anywhere else, they didn't depose a corporate rep. They deposed Mr. Escoffi in his personal capacity, who said, I don't know anything, I was learning, Donald Triplett was doing everything, I don't recognize an email. And they said, that's impossible. You have to recognize an email with your name on it for this company, even though you're testifying you're not doing much for it.
Throughout the case, there was this pairing of the email problem and the QuickBooks problem, and I think it's important to note that the Court of Appeals said, yes as to one, but no as to the other, and you're not complaining about the Court of Appeals' conclusion that there was spoliation that the Court of Appeals found.
The Court of Appeals skipped the very first step because they just went on to the rest.
You're not complaining about
I'm
that.
not, because they reversed, they remanded for new trial, and so we thought that was a fair decision on balance, and we weren't. I think that they did not get to that first step, and they got to the right final decision. But they didn't even address whether or not it was requested. They didn't. The very first step under Brookshire Brothers is do you have a duty to preserve the evidence? They said, we're not going to address that. We're going to go to the breach part. They just assumed it for sake of argument that it had been met.
Well, here's the question. Given that the Court of Appeals found that there was sufficient, basis to find spoliation as to the emails, how does that factor into the harm analysis question?
The harm analysis, I think that the court...
So the harm analysis, even the Court of Appeals says it was legitimate as to the emails, if not also the QuickBooks.
So with any sanction, including with spoliation, the trial court has a duty to make sure that the sanction is not excessive, that it restores the parties to a fair approximation of what they would have been anyway. And one of the things that should be done is to test whether any other sanction would have been available. Here, there was no discussion at the spoliation hearing, no argument that we need these emails because we think that they will show X. There was no discussion about that. So the relevance of them, how they couldn't get to this evidence in any other way, was never discussed at the trial court level. For the trial court to even consider, hey, yes, these emails are so important because of this reason, therefore I'm going to issue the sanction. There were lots of other available remedies that could have been done. If additional discovery was needed to find out what these emails would have said, they could have taken more depositions of the homeowners. On our dime, as a sanction, they could have deposed a corporate rep for Copper Creek. At our dime. There were other sanctions that could have been tested that just were not even considered or thought of. And it was just this assumption that emails are so important. And that's kind of, I think, a fallacy in this whole notion. As a lawyer, I deal with emails all day long. So if I'm looking at a case, I need to have emails. These are field workers who the testimony at trial says that they were directed verbally to go to sites. So how emails to people who there's never been any foundation laid that they even have an email account or getting email instructions is somehow going to be important to this case. I don't think that was even shown. How emails about what? They never said, give us all of your emails.
Help me with the charge, though. So the Court of Appeals says, based on the record, the trial court did not abuse its discretion by concluding Platinum met its burden to show CCDI intentionally or negligently breached its duty to preserve evidence. Is that the equivalent of saying the trial court would have correctly given the spoliation instruction if it had been limited to emails and not mentioned the accounting records at all?
I think that the Court of Appeals decided that, as a fact finder, that it had at least some testimony and evidence that I think that it didn't do a full enough analysis. At the spoliation hearing, one of their major issues was the credibility of Mr. Triplett, because they got in his 20-year-old criminal history over objection and said, well, you can't believe anything he says. So I think the Court of Appeals said, well, we can, as a fact finder, you were the one to believe or discount what happened to emails. And I think that the analysis at the end was correct, that the harm imposed. During closing, they said the first and foremost, most important jury instruction is spoliation. They made it the centerpiece of their trial. They mentioned it in voir dire. There's references in closing that missing pieces, as earlier we talked about the missing pieces. There's nothing in the trial record about missing pieces. It had to have been voir dire, which Mr. Gibson in his closing referenced back to that closing about how, how they were talking about these missing pieces in voir dire. They made it, they mentioned it in their opening statement. They questioned Mr. Scoffey and Mr. Triplett about about spoliated evidence, and they said it was the most important thing in closing. It's not your most important thing in closing if you don't really need it. If they had all of this evidence to prove up their case, why do you go to a spoliation hearing and say, well, we can't prove our case otherwise? It doesn't reconcile with each other. They didn't
at volume 4 of the reporter's record, the place just before the jury comes in where someone objects to the spoliation instruction. I should have done it earlier. The defendant objects to the inclusion of a spoliation instruction. Was there ever an objection that was more specifically addressing any of the particulars of the instruction? Did there need to be, number one, and was there ever another objection, or is this pretty general objection to the instruction itself, all that there is?
There was I think that Wackenhurt is instructive here from this court, very closely aligned there. We had an entire spoliation hearing where this was an issue is contested, and the court said, I'm inclined to grant it. Prior to trial, he said, I am granting it.
But there was no discussion about what it would look like.
No, and we would have objected to any instruction. There was no version of an instruction that we would have been happy with.
Understood. But then at some point, doesn't it sort of rest on you to say, well, I understand I've lost the war here, but another battle I want to fight is maybe you should strike this word, knowing that I'm losing, that you are giving a spoliation instruction. Isn't that your burden, to then tinker with the words of what the instruction actually says? I think
that goes to Wackenhurt, and that's the scenario there was they did not object to the specific instruction and did it after, and the Supreme Court in that case said it was plain that they would have objected to any instruction. The trial court knew what the error was. You don't have to object every single time and just give up at trial to preserve your evidence. So I think Wackenhurt is instructive here, and we did not waive that error.
But there's no more particular instruction. It's a huge record, is why I'm asking you to confirm.
Yes, it is a huge record.
This is the objection that you're relying on.
Yes.
Yeah, okay.
It is a huge record, and that's part of my issue is trying to make sure I get to everything. At trial, Sean Valk said that with these QR codes, they could, within a few feet on planet Earth, know where these workers were. That was again mentioned during their closing, that these workers don't know, but we know exactly where they're at. Mr. Sean Valk also testified during trial that he noticed Daryl Briggs off-site in September, and then he addressed it with Donald Triplett a month later. So for a month, they're doing this investigation, apparently looking at time records as to where these workers are. know the addresses, so know the homeowners, or have the ability to identify the homeowners, know how many of them there are, know the identities of these workers, but not a single worker was brought to trial to say, yes, I worked for Copper Creek, instead of I worked for Donald Triplett. Not a single one. At least 10, more than a dozen of those same workers were once parties in this very lawsuit before it morphed into Donnie Escoffi is the alter ego of Copper Creek.
Do you agree that there is some evidence of some damage that was put on that has nothing to do with taking a negative inference of what the missing documents would have revealed?
The evidence that they put on was untimely disclosed, and we objected to it as being expert testimony. Setting aside all those objections.
It's very difficult to argue that their evidence was untimely disclosed in the face of a record where you're battling against a spoliation instruction, right? So let's just talk about the evidence that the trial court admitted.
I think that there were still problems with that evidence as far as who was the sponsoring author of it and how they arrived at it. I think it was a conclusory. There were a whole lot of other issues as to what those damages were. They also didn't choose a remedy at the end and got at least duplicative damages because they didn't choose a theory. Some evidence, maybe, but we don't know exactly how much import the jury put on that versus other information because of the spoliation instruction. It overrode everything, which is why I think the Court of Appeals rightly recognized that you can't get some of those sufficiency arguments because we don't know what the jury was relying on, and we also don't know, if they would put on more evidence. There wasn't anything other than Copper Creek and Triplett are owners of a company, so it must be Copper Creek as opposed to any other of the 16 entities that Donald Triplett had. There is no direct evidence that despite having their entire financial life, but for QuickBooks, in a QuickBooks format, QuickBooks is a summary of other information. You input data into QuickBooks. It spits out profit and loss statements. They had profit and loss statements. I assume that their argument is we didn't have the native documents from QuickBooks, the QuickBooks backup file. The harm here was extreme. I think that there's no evidence that the trial court considered any lesser sanction or tested any lesser sanction. They filed a motion to compel but never got an order on it. There was never any other sanctions hearing. So there's
What's the best authority that error that you're complaining about, the failure to recite on the record that I've tested, I've thought about lesser sanctions, is that itself subject to a harmless error analysis?
I think it's still part of the harmless error analysis, yes, but I think that, and I don't think that the Court of Appeals said that it had to be offered on the record. It said that the record had to show. So there's no magic words that lesser sanctions weren't tested. It's that, if you had been sanctioned, or ordered to compel, and it's just very abundantly clear that we've done everything we could to get this person to comply, and we had to go to that last drastic step, because this court has acknowledged that tipping the scales or nudging the scales with the spoliation instruction is drastic. So it should be almost the matter of last resort, not any other sanctions have been given. In fact, a sanction for perjury was denied because they believed Donnie when he said, I don't know what those emails are because it's not me.
Any further questions? Thank you, Mr. Herod.
Thank you.
Mr. Sherry, you have 5 minutes.
Thank you, Mr. Chief Justice. A few points. As to the question Justice Huddle was asking near the end there, every reversible error requires a harmless error analysis. This court has held that over and over again. There are no exceptions to the harmless error rule. The distinct error that the Court of Appeals found in the trial court not providing either an oral record analysis of lesser sanctions or the appropriateness of an instruction or written findings to that effect is, if it was error at all, is an error that itself has to be analyzed for harm. And that means the Court of Appeals needed to make its own determination about whether the record supported a spoliation instruction in this case, given that it affirmed the trial court's finding that there was a culpable spoliation of the emails. And that analysis is absent. Why Copper Creek instead of the 16 other companies owned or operated in some capacity by Mr. Triplett? Because the evidence showed that Mr. Triplett and Mr. Briggs, both of whom were employed by the plaintiff, by the petitioner, were diverting labor to these projects, and Copper Creek is the only business they were in together. Okay? This is an argument they made at trial that the jury was free to discredit and right to discredit. It's an incredible claim that those two were working together for the benefit of some company other than the one that they owned and operated together, both pre and post incorporation. What is the relevance of the emails? It's obviously hard to say this in cases where we got a grand total of one email produced to us by someone who bought the email account after they had allowed it to lapse, or, according to the records we got from GoDaddy, deleted it days after this lawsuit was filed. But what we do know from the invoices that Copper Creek submitted to us, both pre and post incorporation, is that they were using that email account for their invoicing to customers. The invoices that we received from Copper Creek pre and post incorporation included charges for material and labor, okay? So I think one of the criticisms that's been raised over and over again is, why didn't you do this in discovery? Why didn't you do that in discovery? Spoliation can be prejudicial not only at trial, but also during discovery. We know that that email account, because we got invoices from it, would have helped us identify the customers that we might have subpoenaed. We know that the email account and the QuickBook records might have helped us identify which of the up to 160 laborers employed at our 2 job sites had been diverted to other work, right? Are we supposed to interview all 160, not having evidence that we can confront them with, showing that they've gone off site? The spoliation of this evidence had a devastating effect on the case. It had a devastating effect on the development of the case during discovery and on the presentation of the case at trial. The instruction was entirely warranted. The QR codes. With the QR codes, we would have known exactly where they are and where they weren't. 2 things about the QR codes. First of all, Sean Valk detected that some of their laborers were being taken off-site because the QR codes showed them off-site. The GPS data actually showed them working at non-platinum products. That's in the record, Reporter's Record Volume 3 at 102 to 104. Also, the time records that were kept for the 2 projects that Mr. Triplett was in charge of had a vastly disproportionate number compared to other of the plaintiff's projects of manual entries, meaning entries that were not created by the scanning of the QR code, which would give you a GPS location, but instead put in by Mr. Triplett himself. The QR codes and how those work were one of the things that alerted our clients to the fact that the labor
So the
theft
jury
improved at a
heard this
trial.
evidence and could have concluded that the manual entries were fraudulent. Why the need for the trial court instruction?
Well, both because there are emails and QuickBooks, and because the evidence that we would reasonably expect to find in them, based on what we know about those sources of evidence, go not only to liability but also to damage. Mr. Triplett testified that everything related to CCDI's finances, that's his word, everything, related to CCDI's finances in 2017 was in QuickBooks. None of it was produced. Mr. Escofi, far from not having his fingerprints on any of this, testified that he prepared the profit and loss statements and the income statements, the few 16 pages of hard copy financial records that were produced. Okay? Mr. Escofi, by the time of discovery in this case, to respond to a couple of these other points, was the sole...
You're reciting overwhelming evidence of your claims and your damages. And so what I'm wondering is, and this is without ever having received those documents, so what I'm wondering is why the need for the instruction?
Your
As
Honor,
opposed to just,
Your Honor,
standing on the strength of your case and alerting the jury to the inconsistencies in their positions and the failure to support their profit and loss statements with QuickBooks or anything like that.
Your Honor, I think the question that you're asking goes right to the heart of the absence of a harm analysis and what harmless error means. It's implicit, at least, in making a harmless error argument that we would have won anyway. But the fact that the error is harmless is why you don't reverse. I mean, it's why you don't order a new trial. It will always be the case in a case of harmless error that there was a strong case notwithstanding some mistake. And that is the situation that we have here. A spoliation instruction was warranted on the Brookshire analysis. There was a duty to preserve. There was a culpable destruction in the case of the emails. The records received from GoDaddy showed that those accounts were created in early 2017, February 2017, right around the time they started invoicing us for Copper Creek cabinetry, and deleted in February and March 2018, very shortly after Mr. Triplett was sued and after we can show in the record that he was aware of the lawsuit. I think one of those email accounts was deleted the day after, or the date that we filed the motion for substituted service. I'm over by a minute and a half.
Any
Thank
further
you, Your Honor.
questions? Thank you, Mr. Sherry. Thank you to all counsel. I also want to say thank you to the two very well-dressed and well-behaved assistants behind your co-counsel. We're glad you were here with us today. That concludes, the case is submitted. That concludes the arguments for today, and the marshal will adjourn the court.
Arise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.